Hello and welcome to this first lecture of this series. This is a Law of Evidence series where I will be covering various topics to do with law of evidence, and this is just really an introduction lecture, just giving you an idea of what I intend to cover over the next year or so when I'm doing these lectures for evidence law. A bit about me. I am Charlie. I am a law LLB student at the University of Leicester. So by the end of this session, you should be able to outline the topics which we're going to be covering in this series, as well as describe the main skills to be developed in this series. But let's get straight to it and give you some general information about this video series. So this is not a replacement for your actual lectures at your university. My lecture series here, if you're a university student, is just for consolidation and revision, not a replacement. And that's the same for me. These videos, this series, is for my consolidation and revision as well. It's not a replacement for any lectures at all. That's because different universities cover it differently. And normally you have subject experts such as barristers teaching it, so you don't want to really miss that. If you do have any questions at all about anything, the series or the things we cover, please put it down in the comment section below. And as I said, check your individual course materials, because not everything I intend to cover may be covered on your course, and there might be various differences, so be aware of that. And ultimately, although this is a good way to revise, especially if you're walking or doing something where you're not on the desk and you just want to listen to something as part of passive revision, that's fine, but you also need to do active revision in order to really do your very, very best. So that brings me on to the next topic. There's many different types of assessment which, depending on where you're studying, you could be exposed to. So multiple choice questions and single best answer questions are particularly important for those professional courses like the bar course and the solicitors training course. You might be asked to do essays, problem questions, case comments, or even presentations of some description. Obviously, I am unable to provide all the support for every different type of assessment you might have in your individual course, but I will try and create some tutorial seminar style questions in due course so you can practice answering questions, and hopefully I can also do some videos going through them as if it was a tutorial. But again, this is not a replacement for anything you have as part of your actual course, but more of an accompaniment to help you with your revision. And as such, whenever we're going through this series, some of the key skills which we plan to develop are the skills of critical analysis, questioning the law, problem spotting and solving, so seeing where problems may lay and how the law will solve them. That leads into the application of the law, and by doing this we will also improve our communication, both written and oral, teamwork, because you might be working with your peers when you're doing your evidence course, as well as independence due to the independent nature of university study. But anyway, shall we go straight into the topics which I intend to cover? So firstly, it will be burden and standard of proof, and we'll be looking at who bears the burdens in different scenarios, what the different standards are. For instance, we've got criminal standards, civil standards, and then all the different exceptions. So for instance, when the burden in a criminal case goes from the prosecution to the defence, for instance. So we'll be looking at all of that. After we've covered that, we will then go on to the second topic, which will be confessions and inferences from silence. So we'll look at the general rules around both confessions, inferences from silence, then some of the exceptions. So, for instance, confessions and inferences from silence might be allowed or might not be allowed, depending on the different facts of the case. And so this is a particularly interesting area in my opinion, especially considering the vast range of miscarriages of justice in the England and Wales criminal justice system. most notably the post office scandal, which has been very visible in recent years, and is seen as one of the biggest miscarriages of justice in British legal history. After we've covered this though, we will go on to topic 3, which will be the questioning of witnesses, special measures for vulnerable and intimidated witnesses. So we'll be looking at questioning techniques. So what questions can you ask, what questions can you not ask, support available for the witnesses, so if they are vulnerable, if it's been a while since the actual crime or whatever took place, are they allowed help? And we will also evaluate the strengths and weaknesses of different witness testimony, how valid, how valuable it actually may be. After we've done this, the next one really follows on nicely, because topic 4 is about the evidence of character, and this can apply both to the defendant or the person who is being taken to court, as well as the witnesses. So we'll look at the criteria when it comes to good character, bad character, different rules for when it's criminal compared to civil, and the different scenarios and exceptions. So for instance, if the defendant portrays the witness in a bad character, are the other side then allowed to produce evidence of good character? So we'll be looking at all of that. And once we've gone on from character evidence, we go a bit away from the actual courtroom and to the more external evidence. So we will have identification evidence, where we will look at the various types of identification evidence, as well as the different rules around the admissibility of that evidence. And again, we will evaluate identification evidence, so strengths and limitations, how accurate will it be, how valuable is it in preventing miscarriages of justice, for instance. And then the next topic is probably one of the biggest topics, and that's the rules around hearsay evidence. So there's general rule that ideally no hearsay evidence at all, but then there's various exceptions when it comes to hearsay evidence, as well as synoptic links. So the rules around hearsay evidence also apply to various other areas of what I will be covering, and it links into all different areas. So for instance, the topic on witnesses, there's crossovers with hearsay evidence there, for instance. After we've looked at hearsay evidence, we will then go on to looking at opinion evidence in a way, in terms of expert evidence. So we'll look at the expert's duty to the courts and the questioning of experts, as well as the admissibility of expert evidence. And obviously, experts are a special class of individuals because they are allowed to present an opinion, whereas normally we look for facts, what the individual witness normally saw, whereas here it's a bit more, there's a bit more flexibility, if you like. Then we finally conclude with topic 8, which will be looking at illegally and improperly obtained evidence. So we'll be looking at miscarriages of justice. So as I said, post office scandal, for instance, Birmingham 6, confessions, Birmingham 6 coming again there, honey traps. So there's Colin Stagg and from Wimbledon, I think it is, or Wembley. There's also various other different examples of where the criminal justice system have got it wrong, and we'll be looking at what safety mechanisms are in place to try and prevent things from going wrong, and actually how effective are those methods to try and protect the innocent. And I suppose this goes back to that legal principle that it's better that 1,000 guilty people go free than one innocent person gets imprisoned, for instance. And so now, following this short introductory lecture, you should be aware of the topics I plan to cover in this Law of Evidence series, and be able to describe the main skills which I hope will be developed, and I'll help develop these skills in various ways throughout. But just to conclude, please do like, comment and subscribe for more content. If you like it, it shows me you're engaging. Again, if you're commenting, again, it shows me you're engaging and that there's need for this content, that people want it. And if you subscribe, not only that supports me, but that will also encourage me to make more videos, and you will get notified for future videos as well. and I plan to cover more topics found in a law LLB degree, as well as more expert professional level study as well. If you have any questions or feedback, again, please put it in the comments, and also do support me. I'm doing all this for free, for my benefit and your benefit. And so I've got some links in the comment section where you can support me financially, and there will be future videos where I will explain why I'm asking for financial support, but it's really so I can continue to develop my academic expertise in the law and be able to help as many people as possible, whether that's through pro bono legal activities, which I plan to do when I qualify as a barrister, or whether that's through public legal education, through lectures like this, which are publicly available. But I hope that is all good, and I look forward to seeing you in the next lecture. Goodbye.